This is the possibilities and perils of Supreme Court reform overhaul. And what we're hoping to do today is take on some of the ideas that have been certainly kicking around for decades, but have really re-emerged with force right now, and explore the reasons why for this phenomenon. Look at a couple of the particular proposals, strengths, weaknesses, and just how some of the candidates might respond to them, what sort of pushback conservatives might have, and just try to be lively here. Now, we have an hour, about an hour before we take your questions, which seems like a wide expanse of time to someone like me up here, but we've got 6 voices, so what we're gonna try to do in the beginning is to be fairly brisk, to try to lay out some themes and to have some of our panelists explain their own proposals, and then we're gonna take more time to explore the details. And please think of your own questions as we get into our discussion. A couple of bookkeeping elements, of course, turn off or down your cell phones. Make sure that if you want the CLE credit, you know that the table is outside to sign up there. Think of your questions. People will be going around trying to collect the cards. We're gonna leave about 20 minutes for questions, so we'll have plenty of time for that. And if you're on Twitter, the hashtag is, let's see, hashtag ACS 2019. Okay, so that's that, but let me also briefly introduce our panelists. More thorough bios are in the program, but from my far right, Dahlia Lithwick from Slate, Aziz Hook from the University of Chicago, Bob Bauer at New York University Law School, Ganesh Sitarama at Vanderbilt now, Aaron Belkin at San Francisco State, and Neil Siegel at Duke. And just to sort of start us off to figure out how did we get to this moment when we're talking about proposals that date to the 1930s and FDR's failed attempt, and we're talking about proposals for something that hasn't changed in America for 150 years when Congress last set the number of justices at 9. We'll start with you, Dahlia. Why?
We could have a whole plenary just called Why. So thanks, Joan. Thanks to ACS for inviting me. I always feel like this is like the best bat mitzvah party of the year. You just look around and see that you're heroes and the people that are working so hard. It's great to be here. So how did we get here? I think Senator Hirono captured most of it, so I'll be brief, but I think essentially the reason that we're sitting on this stage talking about Supreme Court reform is that within hours of the death of Justice Scalia, we were hearing from Republican leadership in the Senate that whoever Barack Obama chose, it could have been Scalia's son, was not going to get a hearing or a vote, and that seat would be held open until the election. And more importantly, when Barack Obama picked Merrick Garland, it was very clear there were people in the Senate who were not even going to meet with him, not going to have a courtesy meeting, much less a hearing or a vote. And I just want to make one point, which is was under what Senator Hirono said, but I think it's important, which is that over the course of the summer, that summer of the election, Senate Republicans went from saying, when they were asked, why are you blocking, why are you not at least going to give this man a fair hearing, went from sort of saying, squirrel, look over there, we don't want to talk about what we're doing, to overtly campaigning by September and October. Senate Republicans were saying, we will live with 8 seats, we can go down to 6 seats. If you elect me to the Senate, says John McCain, says Ted Cruz, we will have 4 more years or 8 more years of 6 seats, but Hillary Clinton will seat no one on the Senate. So there was one side that was overtly campaigning on a court of 8 people or 6 people, and another side, I say with some dismay, that was not campaigning on this issue at all. That was not saying, I will fight for Merrick Garland, I will fight for the court. And I say all this to say that in the 2016 election, exit polling showed that by a 2-to-1 margin, people who said the court was their #1 voting issue broke for Donald Trump, because Donald Trump promised them exactly what he has now given them, which is that this would be his singular priority. There's a piece in the Times today saying the only thing the Senate is now doing under Mitch McConnell, is processing judges in the numbers that Senator Hirono just told you about. And all of this is just to say we're here in some part because we like to say they did this to us, but I just want to start by saying a little bit we did this to us, that there was a little bit of a gap in focus and enthusiasm and passion around the issue of the court and how we went into an election with an empty seat, 3 octogenarians, and didn't make it the single most important issue that voters were talking about. That's also a little bit of why we're here.
You know, I'm reminded of the fact that at the Democratic National Convention that summer, Merrick Garland's name was not raised at all, and some of us made news stories out of it. And I do have to say that his name seems to be in the air much more now than in 2016 when he was, you know, dangling out there without any kind of Senate hearing. Now, Neil, I know you're going to push back on some of the proposals, but could you just elaborate a little bit more, join with Dahlia, on how we got to this moment and how you think some people, it shows that people just think something is wrong right now. Just briefly.
Yeah, sure. First, hi, it's good to be here. It's likely overdetermined why we're talking about what we're talking about on this panel and more generally now. I think I would put 2 reasons, 2 explanations front and center. The first has to do with, well, the name of the plenary is, you know, why are we here? We know Mitch McConnell's response, right? Or if the question is why, right? The response is because I can, right? That's been his response. That's been President Trump's response. What you're seeing is norm-defying, constitution-undermining, I've called it deeply anti-constitutional behavior from the president, from the Senate Majority Leader, with respect to judicial nominations and many other things as well. And I think there's a sense, an emerging sense on the left, that you don't want to be a consistent loser in a prisoner's dilemma. There has to be some kind of consequences for norm violations in order for those norms to be restored and respected. And we'll talk about whether some of these proposals amount to tit for tat or conflict escalation. But I think that's part of the explanation, is that very bad behavior has resulted in a court that is now substantially more conservative than a majority of the population. We had a minority president nominating 2 decisive justices confirmed by a minority Senate, by which I mean a Senate that represents a minority of the population. And so this court arguably lacks actual democratic legitimacy to move the law substantially to the right, which doesn't mean that's not what they're going to do. That's the first reason. I think the second reason, and Dahlia touched on this, and I think she did it gently, and I will not do it gently. I think liberals are increasingly finally seeing the freight train coming. You see it with respect to all the abortion bans, the voter suppression, what's going on at the border, the judges, right? The tax, I mean, you want to know someone's values? Look at their budget. That huge tax cut, all the deregulation, appointing people to agencies whose mission is to undermine the agency. And they're liberals, unlike conservatives, I think for decades now, have not prioritized courts and judges. And so let me restate what Senator Hirono said. Courts matter, judges matter, elections matter, right? The old way to pack the court is to win elections. And that is not something that liberals have focused on with respect to the role of judges to nearly the extent conservatives have. And so to a great extent, we have the court right now that very arguably we deserve.
Thanks, Neil. Okay, 4 of our panelists have some specific ideas of what next, what now, and we're going to go in an order that, Aziz, you're going to kind of be mop up of that, because I know that you feel real strongly that progressives are actually relying on the courts too much. So I think that's something we also want to bring into the mix. But Aaron, Ganesh, and Bob, just what do you want? What do you think the candidates should be talking about now, and what makes the most sense before we get into the strengths and weaknesses of those?
Yeah, thank you so much. I'm a political scientist, and I just got scared when the Garland seat was stolen, and I started an organization called Pack the Courts. My pollsters forced me to change the name of the organization to take back the courts, which we're doing now, and to only talk about court expansion instead of court packing. But look, after the midterm victories in November, one of the greatest constitutional scholars in the country left my board and resigned from the organization. And my sense, I can't speak for them, but my sense was that they left the board because they had renewed faith that, as Senator Hirono said, elections can restore democracy, that at the ballot box, we can get our democracy back. And our analysis at Take Back the Courts is that that's unfortunately profoundly wrong. And that effectively, yes, we will still refer to ourselves as a constitutional democracy. Yes, Democrats can even win elections sometimes. But effectively, the democracy is over because the Republicans won't let us govern even when we win elections, because they will obstruct everything or almost everything that we try to do. And then the 5 ultra-conservatives on the court will shred or drastically limit most of of legislation that passes. And that's not a democracy. And it's not a democracy when Black people can't vote. And it's not a democracy when corporate money floods the system. And so our analysis is that, and it's not our idea, it's influence from Brian Beutler and Deirdre Schieffeling and other people have come to this conclusion that there is literally only one chance where we may be able to get our democracy back. And that depends on, of course, winning in 2020, and then coming back and doing 3 things immediately, which is getting rid of the filibuster, expanding the Supreme Court, and then passing a very aggressive version of H.R. 1 plus statehood for DC and Puerto Rico, which the Brennan Center says that would add 50 million voters to the rolls. And that if you do that and see court expansion in the context of saving democracy, look, all the court reform proposals are terrible. Our argument is that court expansion is actually the least risky of the strategies and the only one that has the possibility of restoring the democracy.
And your proposal, how many seats?
Well, to the extent that you believe that President Trump acquired the presidency, through illegitimate means as an unindicted co-conspirator, we don't know how many seats he will have stolen by the end of his term. And so we're not going to get into the numbers for the Supreme Court until we see how many justices he appoints. We also, of course, need to expand the lower courts to make up for all the seats that were blocked in the last 2 years of the Obama administration.
Okay, now, Ganesh, you have more specifics on that. So tell us a little bit about your proposal.
Well, thanks so much. So I think the place that we should start is asking, what are our goals for reforming the Supreme Court? Why do we want to do it, and what are we trying to accomplish? And I think there are really 4 goals here. The first is that we want a Supreme Court that is less political, plays less of a role as a political institution. The second is that we want to reduce the political stakes of nominations. We just went through a bruising court battle over now Justice Kavanaugh. The political stakes of any one of these nominations are horrifying for the country, just as an emotional experience for all of us. We should want to reduce the political stakes. The third is we should want to reduce the importance of all of these particular judges. Whatever your views are on any particular issue, constitutional or policy-wise, the idea that all of that might turn on the idiosyncratic views or the life expectancy of some particular person is not a good way to design a system. We should not have a system based on that kind of structure. And then the fourth goal is that we should want a system that in general has the court being more deferential to the political branches of government and less of a central actor in our political and policy fights. And so to that end, Dan Epps, a professor at Washington University in St. Louis, and I have proposed 2 kinds of reforms to the Supreme Court. The first is that we should appoint every associate justice every Court of Appeals judge as an associate justice on the Supreme Court. So you'd have about 180 associate justices on the Supreme Court, and then the Supreme Court would hear cases in panels of 9 chosen by lottery from the entirety of the Court of Appeals, and there would be a supermajority requirement for overturning statutes. That's the first proposal. We think of that as the lottery approach. And part of this is that it will severely reduce the importance of the particular people and expand the number of people who are participating in these cases. The second proposal we call the balanced bench. You may have heard of it also as a 5-5-5 approach. The idea here is that you have 5 Republican judges, 5 Democratic judges, and those 10 have to unanimously choose 5 judges from the Court of Appeals to sit with them for a year. And these 15 will be the Supreme Court for that year. If the 10 judges can't choose 5, there's no quorum and they're not allowed to hear cases for the year. And so the idea here is that this will force the people on the court to actually find some Court of Appeals judges who both sides can agree are at least relatively balanced in how they think about the law. And we think both of these approaches serve the 4 goals that we have to really reduce the temperature of some of the court fights that we have right now and reduce the political nature of where the Supreme Court is today.
And as I understand it, you believe Congress could do this without any kind of change in the Constitution, as opposed to what Bob's going to talk about in terms of term limits, correct?
So we think that both of these proposals are doable by statute. That is not to say that proposals are always constitutionally perfect. I think any of the proposals that we have constitutional challenges, and I can imagine constitutional arguments against them. But we think that there are strong constitutional arguments for these proposals being doable just by statute.
Okay. And Aaron, just to clarify on yours, are you also thinking statutory?
Yes.
Okay, great. You, however, for term limits, I know there's some debate, Bob, but don't explain your proposal and just whether it would require a constitutional amendment.
Certainly. I mean, it's not my proposal. It is a proposal that has been in development for some time. I think Paul Carrington is associated with it, among others. And it would provide for Supreme Court justices to be limited to terms of 18 years. And the fundamental notion here, going to one of the reform objectives just mentioned, was to reduce the enormous pressure around these Supreme Court nominations and also to avoid a court with members possessing extraordinary power in our democracy who possess that power, keep that power, and exercise that power for decades. And that's, I heard Senator Hirono say just a little while ago, why would we do that with any office in a democracy? And I think that's a fair question. I should mention, when I first wrote on this topic in 2005, Justice O'Connor was giving a speech, and she mentioned it by title along with a couple of other pieces that had been critical of the court along some of these similar lines, and said she saw this as an indication of the mounting attack on the independence of the court. And I thought that was very revealing, that an argument about term limits would be viewed as an attack on the independence of the court. I think the court is an institution with outsized power. I think that it, in that sense, is actually the source of stresses on other norms. And we can have that conversation when we talk about the origins of the whole Merrick Garland controversy. And in my view, the simplest, clearest, I think easiest to explain reform of the court that we could put forward at this time is one in which we say nobody needs to serve on the Supreme Court for longer than 18 years. Every president of the United States, once this cycles into effect, will have an appointment to make, 2 appointments to make, in fact. And that seems to be a reasonable way to put the court back into some proportionate role within our constitutional democracy.
Can I just say, the every president idea, obviously, we had the unusual situation with Jimmy Carter with no appointment,
Yes.
whereas, most others had at least one, that were in modern times. If not, the situation that Donald Trump encountered right away with practically 2 on his doorstep. Would that be, is it your calculation that with the 18-year terms, it would almost automatically be easy to have every president get at least 1 or 2 appointments?
Yeah, absolutely. That's precisely the goal. It becomes just something that we can expect every administration to have to grapple with. But on the other hand, the decisions they make don't have potentially apocalyptic consequences because the terms are limited. It doesn't stand to reason, for example. It's a bizarre lottery that Jimmy Carter didn't have a Supreme Court appointment. But Donald Trump may, depending on what happens next year, what happens between now and next year, may have 2, 3 Supreme Court appointments. Not to go even further to ruin everybody's morning. So it just seems to me that that's an important piece of this proposal. I want to mention in response to proposals like 555 and the lottery system and whatever, I also think the next step in reforming the Supreme Court of the United States has to be one that's relatively comprehensible to voters. Right. I think the radical, I think it's an interesting and innovative proposal, but I think it is very difficult to imagine that it would sell. And I think that if it becomes the front line of the attempt to reform the Supreme Court, it will block all the other reform channels and make it difficult even to get to something like term limits.
You know, I should mention that some of the justices have been asked about some of these proposals this spring in various appearances, including John Paul Stevens, who, you know, is 99 now and served until he was 90 after his appointment in 1975 by Gerald Ford. And he said, you know, he suggested this was all born of the moment and that these proposals will probably fade. But Stephen Breyer this spring was asked at a forum about it, and the 18-year term limits, he said, had some resonance to him. I think in a personal way, he said, it could just stop me from having to worry about when I go. And as we know, Stephen Breyer is 80, a very youthful 80-year-old. Aziz, if you would give us your take briefly, but also respond. I know you feel like progressives have been relying too heavily on the courts, which is a theme that some of our other panelists have hinted at, but why don't you finish up here?
Thanks so much, Joan, and thanks so much to ACS for organizing this discussion. So I grew up in a country which did not have a high court. And it was a country, England, with a reasonable tradition of rights and respect for equality. And so when I think about the role of a high court like our US Supreme Court, I ask what good it does, the polity. Why is it that we choose to have a particular, this particular form of judicial arrangements? Courts are instruments. They serve an end. They produce a particular kind of public good. In this regard, they are no different from a police department, a fire service, a health service, a municipal garbage and sewage system. And you don't design those institutions by somehow reasoning from first principles. You design them by thinking about, well, what is it that we're trying to do in terms of providing a service to the public? From that perspective, I think that progressives have very different policy aims salient to the role of courts than conservatives. I think that there are at least 3 reasons why progressives should view the courts as distinctly less likely to serve their ends than conservative ends. The first reason is specific to the US context. It's that our mechanism of appointment to the federal courts flows through the 2 branches of government, the Electoral College, which creates the presidency, the Senate, which, with all due respect to the members of the Senate that are present, is not demographically representative of the United States. The consequence of making the Electoral College and the Senate the gateways to the federal courts is to predictably skew the composition of the federal courts in ways that match the skew of the Electoral College and the Senate. That is not a skew that will help progressive causes, particularly in the next 50 years. The second reason that progressives should be skeptical of the courts is that progressive goals tend to be redistributive, whereas conservative goals tend to be anti-redistributive. They tend to be focused upon protecting or retrenching elements of some part of the status quo distribution. Now, it is the case that there are certain instances in which courts can redistribute in ways that are highly effective. Obergefell. Obergefell is the redistribution of respect and dignity in a way that is deeply important to many of us. But Obergefell and the form of redistribution in Obergefell is the exception. In the overwhelming majority of instances, progressives will not be able to achieve redistribution, particularly through the way the judicial review, with its focus upon negative rather than positive rights, is organized in the United States. The third reason that progressives should be skeptical is the lessons of history and the lessons of comparison. The federal courts were conceived in the context, as Michael Klarman has shown in his brilliant book, The Framers' Coup, the federal courts were conceived in a moment of deep suspicion of democracy, deep suspicion of the potential that democracy had for redistribution away from propertied elites, and were seen as a check on redistribution. They were seen as a way of protecting property rights. That is hardwired into the Constitution. That is not just the case in the United States. The best comparative constitutional work on the role of courts describes the function of courts, and I'll use a bit of jargon, as hegemonic preservation. You see Supreme Courts being included in both democratic and autocratic constitutions. There's nothing democratic about Supreme Courts. You see them as ways of entrenching the interests of elites that are dominant at the moment of constitutional creation. By design, by function, and by history, courts are not the progressive's friend.
Okay, it seems to me that
And on a lighter note,
yeah. All righty, okay. Thank you. I think all of these proposals and these thoughts about where the courts stand for either the progressives or conservatives' friends, the debate itself, I think, is so worthwhile that if there are flaws or minimum strengths with certain proposals, I think it's okay, because I think I'm so happy as a journalist who wants more attention on the Supreme Court that it seems so much more in play right now in the campaign and in the conversation because of some of these proposals and because of the concerns. So I guess the first thing I'd like in terms of response from Dahlia and Neil is, how can these ideas be communicated in ways that resonate with people, that gets them to want to talk about them more at town halls, which actually we are seeing. We are seeing people at town halls ask the candidates about court packing in a way that, I would never have imagined before. So I want to ask Dahlia just how you think these can be understood by people, and if that's part of making these kinds of arguments about what the court should be doing for progressives or for any Americans. And then also, Neil, I know that that you think some of these are could be counterproductive. So I want to transition into that, and then we can have the various panelists talk about how they've been able to try to get these ideas out there and bring them some salience that could popularize the ideas. Dahlia?
So I warned Bob when we walked in that my instinct in all these conversations about the courts is to agree with the last person who just talked. So I actually agree with every single person who just spoke, and I imagine many of you do too, but I still feel like we missed a beat. And so I think that this conversation, again, is starting a little bit in the middle. And so what my concern is, and I think I sort of glanced at it and then Neil spiked it, but I think my concern is that we have 4 decades of the left being on screen save about the courts. I mean, we just have not engaged with it. We have not talked about it. We have not fought for it. If you ask most progressives, say to me in one declarative sentence what a progressive judge does, as opposed to, whatever balls and strikes or oracular divination of what the framers wanted. There's a wholly realized theory that conservative jurists, even as they're disavowing Brown v. Board, are able to articulate. There isn't an analog on the left. It's something like living constitutionalism married to interpretive dance. It's not a theory. And we have allowed, I think, this conversation to just sort of sit in this fetid pool of, well, we won in the 70s, we must still be winning. And remember, in 2016, when people did not go to the polls about the Supreme Court, they had ample evidence of Shelby County. They had ample evidence of Citizens United. They had a court that had been dismantling workers' rights. It wasn't just Janus that changed things. It changed a long time ago, and we don't clock it, we don't talk about it, we don't track it. And so I say that again, not to say shame on us, but to say, even before we have a conversation about reforming the Supreme Court, we need to convince voters who go to town halls and they're upset about abortion, but that's not enough. That's not enough to change this conversation about the court. We have to have a deep and profound reassessment of what it is we value about the court, if we value the court, if we still want to hold it out as something that is a check and a bulwark, then we have to be able to convey to voters that this matters to them. And I say all this only to make the point, and I think it's a version of the question you asked Neil, is this conversation that we're having now the vehicle by which we are going to teach voters before 2020 to value the court? Is this the way into that conversation? And I think that's where the real friction on this panel probably exists, because there is a real question about whether people seeing conversations about just slamming more justices on the court or going 5-5-5 or suddenly instituting term limits, are voters going to say, oh, that's a way for me to step into this conversation about the importance of the court, or, as I think Neil's going to tell you, is that a way to terrify voters? And I don't know the answer empirically to that. I suspect Aaron does. But my only thought is we have to lay the groundwork to have a conversation about court reform that requires explaining what courts do beyond just this question of do they do or they don't overturn Roe. What courts do is so fundamental and so misunderstood, and particularly, I think, on the political left, we have slept through this conversation. It has happened on the right, and all due respect to ACS, I know we work so hard on this, but it is not a conversation that voters are having because they want to have a big structural conversation about the court. They want to have a conversation about Roe or the environment. That's not a conversation about the court.
You know, it's interesting, Dahlia. I'm remembering the last time there was, you know, I think of Stephen Breyer and Active Liberty and the ideas that he tried to bring to the stump, mainly to counter Antonin Scalia. But there was also a message about, what do we think, about maybe 10 years ago when Barack Obama used the word empathy about judges. And I remember hearing you address thinking that felt a little too touchy-feely for voters and anybody to respond to. But there has to be something in the middle between like a very detailed structural change that may be important but may be difficult to convey versus something that feels so open-ended as empathy.
I was actually a huge fan of empathy. I was the person who tried over and over again to say thank you, Barack Obama, for
What happened to empathy?
What happened to empathy is the minute we had a big, and I think it dovetails with what I said about, you know, there was a massive conservative pushback that empathy meant bias, and empathy meant that you had a thumb on the scale for some people. And when Sonia Sotomayor, who was the person that Obama teed up with the rhetoric of empathy, was asked at her hearings whether empathy has a role, her response was, hell no, because it sounded at that point, there had been no conversation on the left about what it might mean. So I think, again, that was for me an example of how all of the strong messaging and thinking and sort of framing of things happens on one side, and then I think that there's this just crickety sound on the other side. I actually think, not that I think that empathy is a judicial philosophy, but I do think that it was Obama's attempt to inject into the conversation about what progressive judges do, something that sounded like, think about people outside your own experience. That wasn't a terrible thing, but died as quickly as it lived.
Yeah.
Obama never said the word again, I don't think, in connection with judges.
Neil, and then maybe Aaron can jump in then too. Yeah.
Sure. So I wasn't anticipating doing this, but the first thing I want to say in response to my dear friend and co-clerk Aziz is that this is America, baby. I think it would be a mistake of profound historic proportions for progressives to give up on courts and judges. Right? Imagine Donald Trump did not win those 3 Midwestern states by a margin less than a football stadium. And now Merrick Garland is sitting on the US Supreme Court. Imagine how that message lands. And imagine all the other things that had to happen and fall into place for Donald Trump to win. Courts possess a lot of power in this country. They're going to continue to possess a lot of power in this country. And the question is, who is going to be in control of the courts that will be exercising a lot of power in this country? And it's not just Obergefell or Romer and Lawrence and Windsor and Obergefell. It's that whole little issue of reproductive rights. It's that whole issue of the modern free speech tradition and how dissenters need the protections of free speech. It's about the imposition of some sort of humanitarian constraints on the exercise of the death penalty. It's all the rights of criminal defendants that even conservative courts protect to a much greater extent than the majoritarian political process. And so as we criticize courts, as we should, and hold them to account, and I think Aziz named the reason why structurally we have a court that's more conservative than the country, which is what I said a little while ago. Even so, what are you comparing it to? You're comparing it to the democratic political process in which the poor are well represented, right? In which redistribution is easy, in which you don't have special interests in wealth. You don't have state courts around the country day in and day out protecting the rights of vulnerable individuals and groups who otherwise are not going to fare well in the democratic political process. And you also need judges who understand their limited role, that you don't have a democratic warrant to strike down the most significant expansion of the safety net in half a century based upon rather implausible constitutional arguments. And you don't get to try it again and again until you get it right. You need courts there to say no. And so I think it's important to stick up for the role of courts. I want to applaud everyone on the panel for putting forth ideas that are energizing people on the left about the importance of courts and judges. You have certain candidates talking about them. I'm still very concerned that the frontrunners are really not talking about Merrick Garland. They're not talking about, go to their websites. They're not talking about judicial nominations. They're not talking about the future of the courts. They're not talking about everything Senator Hirono said is going on right now in the Senate with respect to the lower courts. I mean, I've got former students who are just, they're really young and they're already on a federal court of appeals. This stuff is all going on. With respect to the particular proposals, I worry that this is part of, I don't think it's technically possible to have an unwitting conspiracy, but I worry that this is part of an unwitting conspiracy to reelect the president, to be talking about major structural reform that is very unlikely to succeed. Some of these proposals are very difficult to understand. You're going to have a very hard time persuading voters that this is a legitimate, appropriate response to bad behavior by the other side, as opposed to breaking rules that have been in place for a very long time for good reason and going well beyond anything that the other side did. Some of these proposals have uncertain consequences, and the Burkean in me worries about them. We had a panel on constitutional norms a few years ago, right? Again, this is not quite in the spirit of preserving important institutions. We're talking about radical reform. Some of these proposals have consequences that I am aware of and I'm worried about. Some of these proposals encounter very significant constitutional objections. And some of these proposals aim at the wrong target. I don't think the goal should be, for example, to make the court not political or above politics, whatever that would mean. Right? The court is, always has been, and should be responsive to changes in democratic politics. That's the basic lesson of democratic constitutionalism. The courts shape the country, and the country shapes the courts. It's a dialogue. That's how we preserve the democratic legitimacy of judicial review. The problem is not that the court is political. The problem, again, is that you have a court that is not democratically responsive to what a majority of the country actually believes about their own constitutional values. And that, I think, is going to only get worse unless liberals mobilize in substantial part around courts and judges and begin winning more elections. And the situation could look profoundly different in 8 years. You could have a Democratic majority on the Supreme Court in 8 years or in 12 years. That is not something that we have to wait 20 or 30 or 40 years for.
Okay, Aaron, you're in the business of trying to figure out what people are talking about. Why are people not talking about the issue of the Supreme Court in the term about Merrick Garland? Everybody here is talking about Merrick Garland, but why aren't the candidates? Why do people feel like this won't resonate even when you go to the basics of what Mitch McConnell did?
The conservative recipe for power is for the forces of greed to incite paranoia, to drive voters to the polls to vote for greed. And what our polling shows is that conservative thought leaders have successfully spent a generation of whipping up their base on the basis of court decisions that they don't like. And so they've taught their own voters that the court can be very, very bad, and they have to go to the polls in order to pursue their values. That whipping up paranoia is not a strategy on the left, and our data show that when progressive thought leaders talk about the court, we tend to talk about the court in terms of positive cases like Grutter-Bollinger or Obergefell or Brown Board. And so we don't have a history of trying to educate our own voters of what's at stake and the danger of the court. My own experience in this issue is that combining that conversation of the damage that the court has already done to workers and women and people of color, the way the court has broken democracy in Shelby and Citizens United, combining that conversation with a very clear proposal for fixing the problem, which is expanding the court, that is motivating. I'll say one more thing about that, which is that we've heard from some of the presidential candidates that we've heard from some of the presidential candidates. It just depends on how dire you think a shape we're in terms of democracy, and if you agree that we are the Titanic after hitting the iceberg or not. But what we're hearing from some of the presidential candidates is that they're going into coffee houses in Iowa, and as expected, they're getting questions about healthcare and jobs. But what's unexpected is that people are also asking them, how do we restore democracy? And what's your plan for saving democracy? And just by putting court expansion on the table, what we've seen is that there's a growing awareness among progressive voters and candidates that if if candidates don't have a plan for protecting their agenda from the Supreme Court, then they really can't be taken seriously as candidates. And so that's part of the reason why the discussion of court expansion, to my mind, has been energizing, and that it's a clear, simple idea that people are able to rally around.
Thanks. You know, Bob, the reason I want to turn to you is I think you probably have more experience than any of us actually working with candidates, working with the politicians. First of all, how do you respond to Aaron's basic point about this sell that conservatives have made about the court and the failures of progressives to connect? And who should be communicating this message? I mean, it should, a bit to Dahlia's point, should liberal justices be speaking out more about this? Should Democratic candidates, should Democratic leaders, who should convey the message that should resonate with people to believe the court should be a greater issue in the election or at any time?
So it seems to me that we have put together two lines of argument about the court that I think we ought to separate. One is an argument about reform that should take place whenever. As I was not saying, that there are two lines of argument about reform. One of them is sort of an argument that it ought to be sort of considered on its merits and is part of a broader question about how our institutions are functioning and in what ways they might be fixed. The other is the one that might have some political salience and be directed to the electorate in some way and mobilize the electorate around these issues. Of course, then there's a question about which electorate are you referring to? I think the Democratic primary electorate response to these issues is very different from the general electorate response to these issues. So you can't make the same argument to the one that you make to the other. If you go to certain Democratic primary electorates, their argument is the court that I want is not a court you're presenting to me as an apolitical court, as a court that reflects my values and produces constitutional jurisprudence consistent with my preferences. Is that the same argument that you were going to make, for example, to voters that you're trying to peel away from the Republicans in Wisconsin, Pennsylvania, and Michigan? I don't know that it is. So I just want to stress that the term limits argument, I do not believe, is going to bring thousands of people to the barricades by any stretch of the imagination, although I would also say that in the general election, in a country that the polling demonstrates is extremely concerned about the free-for-all in Washington, D.C., the instability of the tone, abuse of power, apparent inability of adults elected to public office to work together collaboratively, I don't know that an argument about institutional reform is completely useless, but I grant you it wouldn't come at the very top of the list. So I also want to just add one other sort of cautionary note about, what does it mean to say to people, our courts should be apolitical. If given a choice around the country where voters can actually elect their Supreme Court justices, they prefer to proceed by election, which used to drive Sandra Day O'Connor crazy, right? That's what they want. They view judges as accountable in some way to them for the decisions that they render. And then I'll stop there because I know there are a lot of people on the panel, there's a lot to be said on this topic. I just want to add, Merrick Garland's name has come up quite a bit in the conversation here. I don't think that this is an argument that's going to have any, really, frankly, rallying appeal in the general election. I mean, it's hard for me to think. Most voters have never heard of Merrick Garland and probably are going to wonder why it is that this subject is being brought up again. And what it probably reflects to them is just that Washington was dysfunctional yet again. There was a free-for-all in Washington, and somebody named Merrick Garland was yet another one of the victims. But I do think it would be helpful at some point in the conversation, Joan, to come back to the question of what we draw from the Merrick Garland episode. I think that it is, the name Mitch McConnell comes up, obviously, shivers go up our spine. And this was a very, very ugly episode. Having said that, it was entirely inevitable that it was going to happen. The norm that was violated was under extraordinary stress. It took Mitch McConnell to seize the moment with alacrity. But I think it's important to talk about it as something other than sort of some isolated constitutional criminal offense that occurred. I think it points us in the direction of how these norms were under stress and why it is that these long-term institutional reform questions like term limits ought not to just be cast as aside as sort of too bland, too neutral, too lacking, if you will, in political sex appeal.
The thing about that moment on February 13th, 2016, when Mitch McConnell did seize the moment, that was a moment he was prepared for. I mean, for those of us who had watched what he had done with the appeals court judges that, I want to get back to you with, on that point, Ganesh, on yours. What a lot of people don't know is that in 2009, as soon as President Obama took office, Mitch McConnell wrote him a letter saying, in essence, our blue slips will really count. We're going to be scrutinizing everything. And we know what happened with the D.C. Circuit. President Obama did not get a single appointment in his first term to the D.C. Circuit precisely because of a very effective, coordinated campaign by the Republican leader. At that point, he was in the minority. Harry Reid was leading the Senate. But it was that moment he was prepared for. He was long prepared for that moment. That's why when he got tipped off early through someone with the Federalist Society, who was a close friend of the Scalia family, he was all set with that statement. So at 5:30 that night, when Chief Justice John Roberts announced that Scalia had passed away, he had his statement. As many people have reported, Barack Obama in California, playing golf, they weren't sure at first how to approach it, and there was a lot of internal stress among the judge-savvy members of the Obama administration over, how to proceed, how quickly, how not quickly. And Merrick Garland was not named until March 13th. And that gave Mitch McConnell obviously plenty of time to then get his people together, because what a lot of folks don't remember is Mitch McConnell certainly was ready for that moment, but other Republicans weren't quite ready for that moment, and he eventually got them all on board. So we know what happened. So I think your point is well taken, is that that was not a really spontaneous move by Mitch McConnell. That was something that was part of a longer, grander plan by someone who is aware of what the courts represent to his people, at least. And on that subject, there are so many strands we want to pick up here, and I want Aziz to see if he wants to respond to what Neil said back a few minutes ago. But I don't want us to lose sight of the fact that we're not just talking the Supreme Court, we're talking all the appeals court judges that Donald Trump has been able to name. At this point in his presidency, he has already doubled the number of appointments to the appeals courts that President Obama had at this point in his presidency. And the idea of, in fact, sort of elevating the role of appeals court judges that comes with your proposal, Ganesh, I just wonder if that they might not be as neutral actors anymore as they could have been in the past. I don't know. Tell us a little bit more, kind of practically speaking, how that would work. And if you want to respond to anything that's been said, then we'll bring in Aziz to defend his statement about how progressives should just not count on the courts.
So great, thanks so much. I'll respond to a couple. I'm going to move this up here. I'll respond to a couple of things. The first is, should we be concerned about the court being political? And I think the answer to that is yes. And the reason why is, if you look at what we have on the court today, we have a court that is 5-4, where the 5 and the 4 are appointed by the political party, by presidents of the political party that is aligned with their ideological views. And that this is actually a pretty surprising thing. And we should expect a series of 5-4 decisions that are along ideological and partisan lines. And this is different even from in the Roosevelt era. When the four horsemen were striking down New Deal programs right and left, Justice McReynolds was a Woodrow Wilson appointee, Democrat. That is a different situation than we face now. And I think in a world where people will look out and say, the Supreme Court is just a partisan institution like any other partisan institution, that is a bad thing for the rule of law in the country and a bad thing for the Constitution, because what it means is that political actors will start saying, well, we don't need to pay attention to this legal decision by some judge or other judges. They're just partisan. There's nothing that's really legal about this. It's all politics. I think that is not something that is good for the rule of law or for our constitutional system in general. And so that's partly why we want to reduce the temperature of some of this. On the balanced court plan, part of what happens when you have the 5 Republicans, the 5 Democrats choosing 5 from the Court of Appeals is that they have to come to some compromise on who those 5 people are going to be. There could be some horse trading. There might be 2 that go partisan in one way, 2 that go partisan the other way, but there's one person that they're going to have to agree on that's got to be at least somehow accessible and acceptable to both sides. And one of the things that the hope is that will do is force them to pick some of those people who are a little bit more available to both sides. And if not, then they just can't hear any cases at all for the year. And that's part of the design of the system is, again, it puts pressure on the court and an ability to try to find some remedy for that.
Okay, thanks. Aaron, you wanted to jump in on real quick?
Just very, very briefly. My critique of the other court reform proposals, in part, is that they have zero chance of getting through the Supreme Court. And this is a moment that is not about...
You mean as a constitutional matter?
Yes, because, we've seen it in Shelby County. We saw it in Bush Gore. The court does not need reasons to strike down things the court doesn't like. And this is not a moment, to my mind, that's about Mitch McConnell or Donald Trump or Merrick Garland. This is about the Republican Party's constitutive addiction to gaslighting that goes back a generation. They cannot avoid gaslighting because of their strategy for for amassing power. And so my mind is that to my mind, it's actually unhealthy and even arguably irresponsible to have an academic debate about reform ideas that can't get through the court, that can't work, that can't sell politically when we're in a dire democracy crisis.
Just one sentence, yeah, right.
So, one thing I think is important for us to think about is, I take Aaron's point to be that the members of the court are acting in bad faith in how they do interpretation, will find ways to come to outcomes that they prefer. If you believe that, though, then we have to note that they would do that in any situation, including the court expansion, for which there are plausible arguments that they could come up with to say that that too is unconstitutional. So I think one of the challenges on constitutionality is if you assume the bad faith as the foundation, it doesn't necessarily mean that there aren't more or less plausible arguments. But if you assume bad faith, you have to assume it across the board, and that includes any of the proposals that anyone might propose.
It's possible.
Yeah.
It's possible.
Aziz, I want to let you respond, and I also was wondering, I think at one point you were proposing not just that we think of courts in a more diminished role, but I didn't know if you wanted to remove kinds of jurisdiction from their agenda also.
Sure. So let me respond directly, Joan, to that question, and I'll try and weave in some thoughts in respect to what Neil said. Realizing that the left and the right have asymmetric payoffs from judicial power has implications for how you think about your goals in terms of court reform. It's not an invitation to give up on courts. It's an invitation to think hard, both about how you mobilize, how you appeal to people with respect to the courts. And here the concern is that if courts are objects of fear on the left and objects of hope on the right, that has implications for whether and how, as Dahlia said, we can talk about them, or politicians can talk about them, and how they might talk about them in the future. But it also has implications for the forms of structural change that might be desirable. There is a pathway of structural change that we haven't talked about that is plainly constitutional and that, in fact, was a modal congressional intervention at least until the 1920s. And it was changing the jurisdiction of the lower federal courts and the US Supreme Court, which Congress has broad but not unlimited power to do. In thinking about whether and how Congress should use its power to shape the agenda of the court, I think it's useful to notice that what courts or federal courts do is not a single thing. Actually, courts are a bundled good. They're like an iPhone, but with less good Siri services. Here are two things that courts do. The first thing that courts do is that they provide retail remedies for individuals whose rights have been violated. So here I'm going to respond a little to Neil. Let's say that your First Amendment rights are violated by a police officer who arrests you because of something you say. Let's say that you are a criminal defendant in a state court who has been denied a confrontation right, who's been denied effective assistance of counsel. Right? The theory is that the federal court should be available to provide a remedy. It's just the theory. In practice, the First Amendment and criminal procedure rights that Neil alluded to are largely out of reach of most litigants because of doctrines like qualified immunity that we saw applied, that we've seen applied aggressively by the Roberts Court in its shadow docket, right? By doctrines of simple non-justiciability, right? The court just this last week held that there simply is no remedy in tort if a police officer arrests you for your speech. If you're a criminal defendant, your chances of getting your constitutional rights vindicated, and this includes capital defendants, are pretty low because of a statute called AEDPA, right? Post-conviction relief for violations of constitutional rights that are, as a matter of fact, endemic in state court systems, as Eve Primus and others have shown, right, are vanishingly rare. So this idea that courts, in fact, protect the First Amendment, the criminal procedure, the Fourth Amendment rights that Americans share is illusory. It's not illusory because of what's going on at the Supreme Court. It's illusory because of the structures through which remedies are titrated. Right, so that's one thing that courts do. The second thing that courts do is that they resolve big policy questions. They resolve questions like the constitutionality of hard-fought healthcare reform, the constitutionality of substantial tranches of the administrative state that keep our, or are supposed to, keep our environment clean and our workplaces safe. And thinking about court reform requires a recognition that the judicial task of retail remedy provision and the judicial task of answering big policy questions are different and distinct, and recognizing that you can alter the jurisdiction of the lower and the US Supreme Court in ways that vindicate the rights of Americans and immigrants within the country and beyond, in ways that simply courts don't do now, while narrowing the scope, and I absolutely recognize that jurisdictional change is not some sort of panacea, but narrowing the scope of the harms that the conservative judiciary that we now have can inflict on an ongoing basis through their ability to give interest groups not a second, not a third, but a fifth or sixth bite at the apple once they have lost in the House and the Senate, and some kind of progressive legislation, be it regulatory change on the environment, be it healthcare reform, has actually been enacted. So I think that there's a space there that is not simply narrowing or expanding the role of the courts, but is thinking carefully about what function the courts ought to play, given that for structural reasons, they are asymmetrically tilted toward conservative ends.
Dahlia, what do you think of that? It's not so much the people, it's the jurisdiction, it's the scope. You know, it obviously, Aziz, your idea, you know, certainly reminiscent of Ronald Reagan in the court stripping era.
I always like being compared to Ronald Reagan.
I know. But you know, that was it was John Roberts versus Ted Olson on that question. For those of us who remember, you know, 2005. But I don't know, Dahlia, why don't you respond to that? And I want to give the other panelists a chance to jump in with any final thoughts before we turn to a very big stack of questions.
I want to respond quickly, and then I actually want to ask you a question, Joan, because I feel like having the John Roberts book expert on the panel warrants you answering one question, and so I'm going to do that at you.
But I've got this stack from everybody else.
I know, but but so my just quick response is I'm actually really happy Aziz framed it that way, because I think it answers the question that we had here about bad faith. I don't think you have to impute bad faith. I think you can just say, Senator Hirono said it, there are hundreds and millions of dollars from the gun industry, and from, you know, there is a machine that creates an asymmetry. It is working as it is meant to do, and it is buying precisely the judicial outcomes that it can afford. And I think that asymmetry is baked in right now, and it's something we have to think about. There isn't parity there. And that's the system, in some sense, you know, that we're stuck with. And so we can have conversations about reform, but to not take into account that there are hundreds and millions of dollars of vested interests in creating exactly the outcomes that Aaron describes, I think is to not recognize that the playing field isn't level. That was a Bob Mueller-like triple negative. But Joan, I think one of the questions that's been in my head the whole time from the minute you asked, you know, you pointed out that Sandra Day O'Connor balked at some of these proposals. and the justices all think of these as court stripping proposals, regardless of what they are, and attacks on the independence of the judiciary, is the thing we haven't talked about, and I'm just curious what you think about it, is in some sense, even the talk of court packing sometimes induces the justices to change their behavior. And we have historical examples, I think, of that. And so I just wonder if your view is, I mean, we've framed this as what will the American public, will they balk at conversations of huge systemic changes at the court, and do they see this as breaking the court because we didn't win? And my question to you is a very, very narrow one, and maybe only just what would John Roberts think, but do conversations like this about what is either court stripping or limiting judicial independence, does that panic him to the point that he conforms his conduct to what progressives are asking for, or does it have the effect of pushing him in the other direction? And maybe that's a ridiculous question, but no, I think that the impact on the justices is almost as interesting to me as the impact on the electorate.
I actually think he's paying close attention to all these conversations. And in November, when he responded most immediately to Donald Trump's line about when the president was disparaging a judge who ruled against him on an asylum question by disparaging him as an Obama judge, and Chief Justice Roberts issued that statement first to the AP and then to the rest of the press corps. You know, there is no such thing as an Obama judge, a Trump judge, a Bush judge, a Clinton judge. I don't think he was just responding to Donald Trump. I think he had in his mind these discussions because they've been in the air. I think he is paying attention to them. I think it does concern him to a degree. He's also a student of history, and he knows that Chief Justice Hughes played a role behind the scenes to help squelch the FDR proposal and to try to reassure members of Congress, members of the Senate particularly. So I think this whole atmosphere of, is the court legitimate, is it not legitimate, I think that cannot help but affect the psyches of these justices, whether they would ever admit to it in any way. I don't think so, but I think what they're all trying to do, you know, the phrase that's come up several times about, you know, lowering the temperature, I think they feel that too. So I think the chief would be completely against it, but I think it does inspire some concern, yes. Does anybody else want to make any quick response to something? Oh, yeah, Bob.
I don't need to jump ahead. I just thought.
No, go ahead. I was just going to say, then I'm going to start.
Yeah. So I wanted to both comment on sort of the hope of potentially diminishing Americans' expectations about the courts, and then conclude with one last pitch for term limits, since okay. I'm trying to sell that proposal. The first is, I think, just as a matter of the American political culture, it's going to be very difficult to persuade Americans that they don't have access to the courthouse door for the things that they really care about, whether it's the enforcement of rights or the institutions stepping up when other institutions in the democracy are failing. They're just going to go to the court. I'm reminded, by the way, of Mitch McConnell saying, speaking of Mitch McConnell, to Donald Trump and to poor Pat Cipollone in the White House, when the president was insisting on his national emergency for the border wall, and Cipollone was expressing doubts that it was legal, Mitch McConnell apparently said to Cipollone, "This is America, everybody sues everybody about everything, let's go." He couldn't care less, because he said it's going to go into court anyway. But I think there's a fundamental underlying truth there, which is Americans have an expectation that the courthouse door will be open. I want to say one last thing about Merrick Garland and that experience, and just go back to the stress on the norm, and then it concludes my point about term limits. I do not believe that the Democratic leadership would have behaved the way that Mitch McConnell did in 2016. I don't believe they should have behaved that way. I want to stipulate that at the outset. I'm not here to defend what Mitch McConnell did. I'm not. But I want everyone to basically engage in a thought experiment, and Dahlia and I talked about this beforehand. It is March of 2008, and George Bush is the president of the United States. And a Supreme Court vacancy suddenly becomes open. He has a 30% approval rating, widely unpopular. We have 2 wars taking place. And we're about to head into, you can push it a little further if you want, troubled economic times. And he wants a Supreme Court appointment and concludes that he's going to nominate a moderate to try to persuade the Democrats to go ahead, hold hearings, and confirm that individual. We know from history that Barack Obama is going to be elected. Maybe it's even likely at the time. And Barack Obama is going to pick someone like Elena Kagan. So you have a choice. Do you want to go ahead and say, yep, I'm going to go ahead and hold a hearing here, and if this is a person of qualification, I'm going to confirm George W. Bush's moderate nomination in 2008 as he's leaving office for a potentially 40-year term, or I'm going to wait until President Obama comes into office and maybe take my chances on someone like Elena Kagan. Think about it. You might go ahead and do all the right things. I would like to believe the Democrats would have honored the process and respected the norms, but it wouldn't have felt good at all. Why? Because it's a 40-year term and there is so much at stake. And so we can talk about Garland, we can talk about McConnell, and I've got lots of critical things to say on that topic, but I also think being somewhat realistic about what put pressure on that norm to the point that an entire political party abandoned it and paid no price merits some of our attention.
Can I make one quick comment?
Go ahead, you're real quick.
I think Dolly is exactly right to focus attention on the effect of these proposals on the justices themselves. Right now, if you think that the Supreme Court and the federal courts are utterly politicized and it couldn't get worse, I would suggest that you don't have much imagination or knowledge of history or
Hey, Neil, I know where you're going. Can I pretend like this is one of the questions
Sure.
real quick? It's how do we change the Supreme Court without turning the court into politicians in black robes and destroying confidence in the
Right.
system?
I mean, it could get a lot worse than it is. I don't think John Roberts is Mitch McConnell. I don't think the U.S. Supreme Court is what's going on in Turkey and Venezuela. And we ought to think it's one thing to talk about this stuff, and there is some pretty good historic evidence that it does have an effect on the judicial mind. It's another thing to go ahead and do it. And I worry about the effect of passing some of these proposals, not so much the 18-year terms, but the court expansion proposals on the justices themselves and them becoming completely and utterly politicized as a result. I would also say that there are substantial constitutional arguments against what Aziz is talking about, court stripping the appellate jurisdiction of the U.S. Supreme Court. I wrote about this with my colleague Kurt Bradley, both on court packing and court stripping in the Georgetown Law Journal. In fact, John Roberts loses that debate with Ted Olson. The Attorney General sides with him, and the official position of the Office of Legal Counsel to this day is that stripping the appellate jurisdiction of the U.S. Supreme Court for political reasons is unconstitutional. I would also add to Aaron that everyone simply assumes that court packing is constitutional. Congress could do it under the necessary and proper clause. There are good faith. I don't think his proposal is free from constitutional difficulty. Let me put it that way. There are textual, structural, and arguments based on historical practice that would suggest that changing the size of the court for particular reasons would run into some constitutional difficulties. And Aaron is right that ultimately it would take the form of a statute, and the Supreme Court would be deciding the constitutionality of that statute, assuming, as seems likely, someone would have standing to challenge its validity.
I'm going to have you respond, but could you build this into it? Because this is, to me, the most practical question about some of these proposals. And this is what someone in the audience said. For those panelists advocating specific reform proposals, how do you protect those reforms from a future Mitch McConnell-esque GOP majority in the Senate? Aren't you just setting up the conservatives?
Yeah, I would say we're already there. And I mean, my argument would be that even if the Democrats obtain the majority through normal rotation at some point down the line, the Republicans will pack the court in response if and when they get the chance. That to me is what they proved in the Garland case. But I guess I would say that just a little bit in response to the counterfactual thought experiment, I think there's an important contextual difference, which is, to me, this moment is not about the breaking of the norm in the Merrick Garland case, because the breaking of the norm has to be contextualized in a generation of phony rhetoric about voter fraud, in a generation of efforts to keep black people from voting through voter suppression, in gerrymandering, in flooding the system with corporate money, and with a commitment to gaslighting. And so, to my mind, the Republican Party cannot be de-radicalized at the ballot box. We thrashed them in '92, in '06, 2008 and again in 2018. And each time the party has become more radical. And I think we're well past the point at which we can afford the luxury of worrying, frankly, about the legitimacy of the court, because there's even more at stake now. The court is a political institution with politicians on the court. On this point about constitutionality, absolutely granted, court expansion might not work, even if it's paired with getting rid of the filibuster and an aggressive version of H.R. 1. But unlike term limits and 555 and jurisdictional stripping, possibly you could expand the court before the court had the chance to weigh in on the constitutionality of court expansion. And so, yeah, we're not arguing at Take Back the Courts project that this will work. We're arguing that it's the least worst possible solution to getting our democracy back.
Do you want to add on both those points?
So I think one of the questions to think about is, to the questioner is, is the proposal plausibly stable? Is this something that you think maybe the other side could agree on and we could reach some sort of new equilibrium eventually? I think each of these plans have a different case for it. Our plans have a case for it. I think the 18-year term plan has a case for it. I think the court expansion has a case for it in the context potentially of a massive realignment, which is maybe what they have in mind on the level of, you have FDR and Truman, and together you just win 20 years of elections, that you sort of have a new equilibrium formed politically. But part of the question is, what's your theory of some sort of political stability around the institutional design? Because I think for a constitutional system to constantly be changing the basic structural design of core elements on a regular basis would be profoundly destabilizing and problematic.
Here's a related thought experiment from the audience. For those of you here on my right, is the panel ready to concede that the Merrick Garland nomination was unwise? An establishment straight white guy who couldn't mobilize anybody, was that a perfect nomination?
If I can just respond quickly, I wasn't in the White House at the time, so I'm free of saying anything that encroaches upon confidentiality or whatnot, or even outlandish claims of privilege. Look, it depends entirely on what governing responsibility you think the president had. Was it an opportunity to recognize that there was no hope, and therefore it should be entirely a public communications initiative? Or was it an attempt to take someone who I happen to admire greatly, Merrick Garland, who's an extremely distinguished jurist, and potentially put him in a position with the hope that some of the Republicans who made it possible for Elena Kagan to go on the court would bend and vote to put Merrick Garland on the court? He took the second course, and I can't criticize him for it at all.
There's a specific one to you, Bob, that I just want to add. How would the current justices phase out, and why 18 years? 18
years, it could be 15 years. As I recall, and you would know better than I would, when John Roberts was in the government, he wrote a memorandum on the question of term limits for judges. I'm not sure it went to the Supreme Court. In any event, it was certainly judicial term limits. And he suggested that 15 years might be a term. I guess it was a proposal that he was evaluating. So I don't know that 15 or 18, there's a particular magic there. The notion would be that, again, each limit would be 18 as current members of the Supreme Court would come to the conclusion of their terms. They would become senior associate justices, and they would continue to have a role. They could, sit on lower court decisions but periodically, if there were vacancies on the United States Supreme Court, come back up and sit on those cases. But the freshly appointed judges, and I think it would play out over the first and the third year of an administration, would only serve for 18 years. And as I mentioned earlier, once the entire program kicked in, because it would take a phase-in period, then every administration would have a choice.
Dahlia, this one's for you. Many religious pro-life voters were mobilized in 2016 on the sole issue of Supreme Court nominations. How can progressives better mobilize voters to care about nominations to the same degree? And I would just mention that because abortion is now so front and center, because of the Brett Kavanaugh nomination and what has been happening in states in just the last couple of months with legislation, can that make a difference in the conversation?
Yeah, I mean, I think that's the question, and I think part of the asymmetry, again, is, you know, you can draw a straight line between religious voters and outcomes in Roe and the Supreme Court, and as Aaron says, decades of messaging that says, you know, the court is awful, it you know, gave the right to kill babies to Americans, and that has been a drumbeat that has been answered by, I think, this sort of snoozy, you know, we won and we're not going to fight for it. So I think part of the problem is that there isn't an analog, which is a sort of religious argument to be made. The analog is, you know, women's reproductive freedom that doesn't necessarily map logically onto a group of voters, except of course it maps logically onto women. And people who care about them. So presumably that's a lot of people. But I think that the problem is, again, that the progressive messaging and thinking around reproductive rights has tended to be, we won in Roe, we won in Casey, and we went home. And the sort of chip, chip, chip erosion of Roe and Casey that's happened at the state level, again, this predates 2016, it predates Brett Kavanaugh. This has been going on, and a lot of people who should have been activated around what was happening in the state houses and states going down to 1 clinics just didn't seem to think that it was worth moving on. So I think the issue is, again, drawing a very straight line that isn't, and I think you and I talked about this on the podcast last week, Joan, but so pitch for Amicus listeners. But I think that what the mistake that I saw happening at the court is that there were lines around the block when whole women's health was argued, because there was some, you know, reason to believe that that was the moment. There were lines around the block when Hobby Lobby was argued, because that was the moment. Right after Hobby Lobby, Little Sisters was argued, same case, nobody showed up. So we get very excited about the thing that we think to be the dramatic moment in reproductive rights. Last month it was Alabama. Guess what? That wasn't it, right? That wasn't it. But we keep kind of honing in very myopically, I think, on the wrong targets. The target is this big, formal, structural, decades-long change at the court and change in the state houses, and that's not something we've done a great job of explaining. And so I think we can't just say, if you showed up, you know, in a red dress to protest Kavanaugh, you should be out there explaining to women what this means in the 2020 election. That's a really hard sentence, but that's the sentence that's not connecting yet.
It's not. Aziz, here's a broader one for you. It's not universally agreed upon that the court requires democratic legitimacy. Does Supreme Court reform necessarily rest on that assumption, and should it?
The relationship between the court and what you might loosely call democratic preferences is a loose one. And I think it's best encapsulated by Robert Dahl in a famous article from the 1950s where he says, well, the court has to have the support of some concatenated faction among elites. And provided the court can assemble that faction, it can usually defend itself sufficiently against criticism. So I think this is what the Dahl thesis is what you saw played out with respect to, or in the wake of Bush v. Gore. I think you'll see a version of that play out if the court upholds the challenged addition of the citizenship question to the census, right? There'll be criticisms of partisan bias in that case, but I think that there'll be a sufficient coalition within the elite to protect it. The role of democratic legitimacy, I think, is different when one's thinking about court reform, because in the court reform domain, it's not some gestalt general view about the court that matters. It's the precise nature of the coalitions that one can assemble at the relevant veto gates across the political system. And then I think, as has already come out, this question about stability, right? To the extent that you can assemble a coalition for some sort of reform that I think all of us agree who've put reforms on the table is somehow lowering stakes, altering the downside risk of courts, right? How does that stay stable? And I think the problem of thinking about the stability or the equilibrium question in court reform is we don't really know what the incentives are on the other side, in the sense that we don't really know, and I think Aaron gestured at this, how committed the Republican Party is to the project of democracy. And depending upon how weak or strong that commitment is, and I will confess, I just don't know. And I think that things like the attempted reneging on gubernatorial wins in North Carolina and Wisconsin is kind of a nice example of how shallow the commitment is above and beyond the White House. Depending upon how shallow it is, the nature of any kind of equilibrium that you can sustain, it changes dramatically, right? If you have a weak enough commitment to democracy, if you're sufficiently adventurous or indifferent to legality and you're willing to embrace arguments that presently are off the wall, well, I'm not sure we should have that many expectations that there's some sort of equilibrium solution to the problem that we're all describing in the absence of some sort of dramatic change in the larger political environment.
We have time for just a couple more, although, okay, yeah. So, sorry, I couldn't see the clock. I can answer one very easy, and then I'm going to ask a broad one. Thank you, thanks. One is, any enthusiasm for changing the number of votes needed to grant cert? Can this be done, and how? The 6 panelists can't do it, but the 9 justices can. I know it takes 4 votes, and it's entirely up to them because they set their own private rules. But here is one for the panel that I think it kind of turns us in another direction, an important direction. How do we get more diverse perspectives on the court? Worker perspectives, for example. How do we address that the justices and their clerks are virtually always very wealthy products of Ivy League institutions? And with the appointment of Brett Kavanaugh, we now have a majority on the court of individuals who were Supreme Court law clerks themselves. And this goes across, ideological party boundaries. President Obama obviously named Elena Kagan, who had clerked for Thurgood Marshall, and Merrick Garland had clerked for William Brennan. Is that something that should be a concern to people up here as they're thinking of restructuring? Neil, you're a former clerk here. I mean, what do you think of that? How to get more perspectives on the court from a progressive president?
I'm not being defensive. This reminds me of the discussion earlier of empathy, which I think was effectively coded by conservatives as emotional as opposed to rational, that liberals have it in the heart, but conservatives have it in the head, and the conservatives follow the law while the liberals just want to make people feel better, right? But to my mind, empathy, right, is part of a rational cognitive process in which I think judges, if they know what they're doing, do what it's most important for the judge to do, which is to imagine the world from multiple different points of view, not as an alternative to good legal analysis, but as part of discharging one's distinctly legal responsibilities. And so if you're thinking about how to apply the words of a statute to a fact pattern, or how to figure out whether vaguely worded constitutional guarantees are applicable in a particular case, you're going to go into this empathizing with someone or some group. That's part of being human. And the question is, are you a good judge? Can you overcome your very partial experience, perspective, values, church you went to when you were young, whatever it is? Now, in order to have a judiciary that's more capable of doing that, I wouldn't start with, well, let's start excluding the Supreme Court clerks, although I don't think we should only have Supreme Court clerks, but it's a genuine diversity of life experiences, a genuine diversity of backgrounds. Why do we have one justice who's done meaningful work in Congress? Oh, and he's also the one least likely to strike down a federal law. Why do we have so many justices who are so identified with the executive branch? And you think that has nothing to do with how popular the theory of the unitary executive is this day? Why do we have only one justice who's ever charged a jury? And when I talk to state judges around the country and give them U.S. Supreme Court updates, they want to know, has Justice so-and-so ever charged a jury? What am I supposed to do with this 5-part test, right? I mean, you want people who can actually think about it from the workers or the employees or the consumer's point of view, then don't just have justices who've worked for employers, right, and corporations, and those who are on the other side of the case. And so, it seems to me it's clear what you do in terms of who you nominate, but that has not at all been the tendency really on either side. I think we don't have former politicians. We don't have justices who understand how Congresses works or what the limits of political possibility are. We don't have any of that. We used to. Now we seem to come to this idea that, well, you want someone who can safely navigate the confirmation process, and that's going to be a very well-credentialed, well-experienced federal appeals court judge. Are there any recent exceptions? Right, Elena Kagan, who is, I mean, she is incredible. I mean, Elena Kagan, you could pretty much put her in anything and she's going to succeed, but that's the exception, right? The clear path is just appeals court judge, record, right? Well, now we're going to have more vetting on the front end going back to high school, right? But very safe people, and the real sacrifice is in terms of a genuine diversity of experience so that you wouldn't just have empathy for particular points of view, but actually multiple points of view.
And segue, we've got time for 2 last ones. And this question has come up, and I think it's a good one. How might a merit-based selection component be built in any way? And I know you've talked about the ethics issues that might come about with if you put more term limits on. But do you think there'd be any room for a bi or nonpartisan commission that would go to the president with a selection of candidates? Or would that, essentially, do we have people? We have a very informal panel right now advising a president. It's just that it's not a nonpartisan commission. It's either the Federalist Society, Heritage Foundation, maybe ACS at another time, that kind of thing. What do you think of that idea?
2 things real quickly. As my last pitch on term limits, since you asked the question about clerks and diversity,
okay, sure. Yeah.
My proposal produces many more clerkship opportunities. Okay. I never thought of that until today, but I walk away with a new argument. Secondly, as far as that's concerned, I think that is fundamentally going to be, and I'm saying this specifically with reference to the very troubled history of the American Bar Association in the rating process, where the Bush administration said, out you go, and the Obama administration brought the ABA back into the pre-screening process. And this continues to be very fraught, very complicated. I think it's really a fundamental question of presidential leadership. Could a president, and I dimly recall that something to this effect, at least at the federal appellate level, was tried by Jimmy Carter, by the way, and I don't remember the details. Could a president say, not the American Bar Association, not a particular committed group with a perspective on constitutional jurisprudence, and no Heritage Society or Federalist Society, but some blue ribbon panel that creates a pool of potential candidates for both the appellate and the Supreme Court together, and that's transparent, and the president commits that is the pool from which he or she will draw, that might very well be a powerful message to send about the way a particular government is run, but I don't know how you accomplish that beyond an exercise of individual presidential leadership.
Here's the last question, and it's a very motivating question, frankly, that anybody can jump in on. We expect the court in 2021, we expand the court in 2021, and in 2025, President